from the Supreme Court because former President John Mahama's legal team has set two processes in motion. One, seeking to halt the Supreme Court's hearing of the 2020 election petition, and another, urging the court to take a second look at its decision that it cannot compel EC chairperson Jane Mensah to testify. Mr. Mahama's team on Monday advanced arguments to support a quest to reopen the case. The court, however, refused that application on Tuesday. Court correspondent Joseph Akable has the rest of the story.
Chief Justice Kwesi Eni-Yeboah on Tuesday delivered a ruling of the court. The court dismissed the request by the petitioner to have his case reopened, indicating that the petitioner has not demonstrated that there is some fresh evidence that was not available at the start of the trial that they seek to obtain from the EC chairperson by reopening their case, which could materially affect the outcome of the case.
The petitioner in this application has not given us an inkling of the new or fresh evidence he wants to bring to the fore through the chairperson of the first respondent, and how that evidence could assist the court to do justice in the matters under consideration in this petition. Neither has he disclosed how that evidence will advance the course of his petition. For the above stated reasons, we find no merit whatsoever in the petitioner's application to reopen his case for the sole purpose of compelling his adversary's intended witness to testify through a subpoena without indicating the sort of evidence he intends to solicit from the said witness and how that evidence is going to help the court in resolving the dispute before us. We accordingly refute the application and proceed without any hesitation to dismiss him.
The petitioner's team have been commenting on this decision by the court, and they say it is very unfair.
The Supreme Court asked itself a question which we deem was a wrong question and answered that question. It said, why does the chairperson need to account to the people of Ghana when she's not a party? We are saying that she violated Article 23 of the Constitution because she's an administrative, body. We have also said her exercise of discretion was contrary to Article 296 of the Constitution. These are all germane issues under the Constitution and laws of Ghana. And to reduce the petition into a single issue petition is rather unfortunate and smacks of a predetermined agenda to rule against the petitioner in this matter.
President Akufo-Addo's legal team, however, disagree.
A bench of 7 justices, and I think on about 2 occasions, 2 others have come to join them to review some of the applications before them. Except for the application for leave to amend the original petition, it is true that all the applications that have come before this court have fallen flat. But how can it be that the petitioner's communication team now argues that the 7 justices or the 9 justices are always wrong in law, and only Mr. Chachuchikata is the one who understands the law, knows the law, and is therefore always right? It cannot be. The last time they won some arguments that some of their paragraphs of Mr. Rojo Metal Nunu's witness statement should not be struck out. You heard them right before you that it was a monumental victory. Are those not the words that they used? And we keep making the point that it is not fair to the judicial system, it's not fair to our democracy, it's not fair to the people of Ghana that when you lose an application because it is not grounded in law or because you have failed to meet the legal standards, then you come here and literally poison the minds of the public and make claims that they may be having a predetermined agenda. That's scandalous of the courts.
The case has been adjourned to Thursday, but as it stands, there are some outstanding issues related to an application for a review of the court's decision, as well as a stay of proceedings that equally remain outstanding. Reporting for Joy News from the Supreme Court, my name is Joseph Akable.